Okay, welcome back. This is the last panel of this type here, and we're trying to actually get the reception started in the next panel, so in the next session. Okay, so this session is about corporate misconduct and the law. The law means what's written and the enforcement. So we're back from the world of norms into law. Now, James Madison famously said, if men were angels, he didn't speak about women, no government would be needed. So in the world of good norms and good people, then we wouldn't have to worry about the law. But I think we had a lot in this conference to suggest that, and even the optimistic person, Peter, said enforcement is essential. It is an area that, thanks to Judge Rakoff, where I know where he is, I got kind of interested in, and I'm now doing research on this issue very much with, among others, Nate Atkinson sitting there, who asked the question before about norms versus enforcement. We know that some men, at least, are not angels, and so we need rules, and we need norms, and we need enforcement. However, rules are written and enforced by also humans, imperfect people. So we're talking about democratic norms and who writes the rules and the politics of writing the rules, also in earlier sessions. Now, in the title of this session is corporations. And Brooke Harrington told us that corporations are among the three building blocks of this secrecy. And we talked about Corporate Transparency Act and things of that sort. So corporations, also a human invention. And, they're not human. I think we agree on that. In a book on bankruptcy law, where Melissa Jacoby calls corporations fake people, but they're not fake, actually. They're not humans. They're not fake. They're very real, and they're very powerful, and they control a lot of our lives. So what are corporations? Well, they go to, a jurisdiction, Delaware, others, Cook Island, and incorporate. And at that point, they get the legal rights that the jurisdiction allows them to have. And it used to be, so corporations are not, as I think somebody said, an American invention. It's actually a Dutch. Rick doesn't agree. We can talk about it later. But the VOC, the Dutch East India, is, by my understanding of history, the first modern corporation in the sense of separateness and asset shielding that it afforded the corporation. And so now we have a legal person, and that legal person lives in the law, as well as the people which this legal entity employs potentially, or maybe it's a shell corporation, doesn't employ many people, just has a director. And now we're asking, what does it mean for the corporation, the legal entity, the legal person, to commit misconduct? What does that mean, and what is the law going to do about it? And of course, as Attorney General, former Attorney General said, many other people, corporations can only act through people. So, what's going to happen to the people? We had one MDB discussed yesterday in Goldman Sachs. What happened to the Goldman Sachs people who were involved? What happened to, one is in jail, one is awaiting trial. It's very unusual. People at the top did know, did encourage, did want the business, did benefit. Occasionally it was clawed back, but nothing really bad happened to them. So this whole issue, why executives don't go to jail, is part of this discussion. Now, when corporations are created, it is by corporate law. So the thing that begins to give them some kind of space to exist and enables them to operate starts with corporate law. And that's where, it controls some of the ways in which, boards work or minority shareholders can do such and such and all of that. And then you might have securities laws to that to protect investors to make this whole thing work. But now the corporation has to obey other laws. Now, in the beginning in the US, or early on in the US, in the 19th century, it was very, very restrictive what corporations could do. And this was mentioned in other contexts as well. So there was a time it was an act of Congress or the king or somebody to incorporate. You had specific duties. You were incorporated for a purpose. And ultra vires was meant to say that you couldn't deviate from that purpose. And also there were corporate governance, corporate law provisions that required, for example, unanimity of shareholders to make any decisions, and that forbade mergers. So you could only exist in a very limited way in the economic space. You could do what you were told to do, and you couldn't move much from that. But yeah, the idea was to raise private money and operate separately, and the government was committed not to take your money. So you needed trustworthy governments to have corporations, and et cetera, and that goes back to the first panel. So I'm going to move on to our panelists just to frame it, saying what we have is Elizabeth Pollman, who's primarily going to talk about corporate law. Corporate law in the US, still is mostly Delaware law, because the way the incorporation comes about in the US is through the states. And states, and in general in incorporation, states often compete for the privilege of hosting the corporation on their land. And Delaware has a business model of corporate law, and hope to keep that business against competition from, Texas or Wyoming or South Dakota. So then, there are trusts and foundations, which is also what Brooke talked about. Anyway, so corporate law is going to be represented here by corporations are supposed to be confounded for lawful sort of activities. So they, in principle, cannot exist if they break the law. What does that translate to? Is corporate law going to make sure they comply with law? Compliance programs, et cetera, et cetera. And then, of course, there's the rest of the law, labor laws, banking laws, different laws all over the place, anti-corruption law, money laundering law. Who enforces them and how? On the corporation, on the people who work for the corporation. So that's the topic. We have, in addition to Elizabeth, we have Ellen Podgor, who was a prosecutor who is an academic who's written a lot about this very issue, corporate enforcement. There, by the way, the law includes regulation. So these are just two different words with technical differences, but they're all rules by the government, enforced mostly by the government, sometimes private actors. And then we have Fabio de Pasquale, who brings us an international flavor from Italy. Italy was mentioned. We had a German politician, and so we'll hear about a transnational case, especially in Italy and other cases. One of his claims to fame is he prosecuted successfully Berlusconi. So that is a feather on his butt. Anyway, and then we have a discussion in the form of, by way of the Jennifer Taub, who knows both corporate law and white-collar crime and more. So with that, Elizabeth.
Thank you so much. Thank you, Anat. Thank you, Didi. Thank you all that have been involved in organizing this conference. In the spirit of many things that Anat, Admati, and her colleagues do, is to try to work across silos. We've heard that. And contributing to each other's understandings. So I thought I'd use my time, a short bit of time this afternoon, to just discuss the role specifically of business law from the US perspective in the conference themes of global capitalism, trust, and accountability. And my key point is a pretty straightforward one, that corporate law is a very imperfect tool or mechanism for corporate accountability. While corporate law embeds some aspect of requiring legal obedience, the reality of enforcing through corporate law itself is very difficult. And I think it's helpful to just know a few basics about why that is. If you're thinking about all of these other areas of law and why can't we do this through corporate law very well, and what does it do? From my perspective, I think regulation and enforcement, and perhaps the way we've been discussing norms, outside of corporate law remains the more straightforward and effective path, most typically, although it depends on the circumstance. And I think the current moment of renewed regulatory competition in state corporate law that we've seen, if you go to corporate law conferences right now, instead of talking about corruption and white-collar crime and those things, instead, many people are focused on what's been happening with Delaware potentially having companies leave Delaware as their state of incorporation. So I thought I would just say a few things about that as well, because I think the current moment that we're seeing with challenges to Delaware's dominance only underscores the point that I started with, the key point, which is that it makes it even less likely that you're going to be using corporate law as an effective tool in most instances to be carrying out efforts at legal obedience of other types of laws. So that's just an overview. So I'll dig in just a quick bit. And I would note, of course, countries around the world have different approaches to business law. Here in the US, we have a bit of an oddity in that we divide our business law into securities law and corporate law. And so just a quick note on securities law. Federal securities law creates mandatory disclosure regimes for public companies. And to put it really briefly, those disclosure rules have traditionally been focused on information that's material for investors. Of course, the information is useful for a variety of other purposes and other stakeholders. There's no requirement of continuous disclosure of all material information from US public companies. Instead, there's detailed rules about periodic and event-based reporting. Private companies have different rules about the information they provide and who they may sell their stock to, while staying within the federal securities law exceptions from the public reporting requirement. So right now in securities law, current debates have been largely focused on issues, for example, about the rise of private markets and companies like SpaceX, for example, staying private longer and potentially even indefinitely, and the issues that may raise about information that we get from those kinds of companies and the number of companies we have that are publicly reporting. But the bottom line is that for private companies, it's generally a much less information-rich environment about those private companies. The main enforcement tool for securities fraud is public enforcement by the DOJ or the SEC, or private enforcement, such as by securities law class actions. So when you think about that as a tool for going after some kind of corporate misconduct, as Matt Levine of Bloomberg has famously said, only a bit tongue-in-cheek, I would say, everything is securities fraud. That is, people will sue Chipotle for not putting enough meat in their burritos, but they do it by saying that Chipotle lied about how much meat they put in their burritos. Or about sexual harassment scandals, or other sorts of corporate misconduct that may come to light. 10b-5 applies, though, to both public and private securities, and sometimes you see things happening like with startup frauds and those sorts of things. But class actions, securities class actions, are usually against public companies, and there's been about 200 securities fraud class actions most years for the past bunch of years. And if you think about that as a tool for going after corporate misconduct, really in a very brief way, you could observe that the effect of that in the big picture, the plaintiffs' lawyers that bring those suits, they contribute to a system that monitors these disclosures, and it provides some measure of deterrence from fraud or lying about what the company is doing. But there's still lots of fraud, and most suits lead to settlements that the companies and their insurance end up paying for. So there's a lot of debate about the value of that, but it's an important part of our system of getting information about companies. Moving on to corporate law, to dig in a little bit about the overview that I started with. So although there's some pertinent federal laws on corporate governance and proxy rules, corporate law in the US is mainly the purview of state law, at least for now still. And under the internal affairs doctrine, as Anat mentioned, the state where you incorporate is the state whose corporate law applies to matters of internal corporate governance and disputes. And corporate law has become generally enabling, so you get to choose that, and you're choosing the law that will apply. The focus of corporate law is primarily on shareholders, directors, and officers. And corporations can have broad purpose. They can generally state their purpose as broadly as any lawful business. So that does create some bottom line essential requirement that they are engaging in lawful business. And the way that most people traditionally think about what corporate law is doing by design there is saying that corporate law is going to be about shareholders, directors, officers. We use fiduciary law for the directors and officers to have some accountability to the shareholders. And we use external law for other matters, environmental, labor, et cetera, et cetera. Now that's a little bit simplified, of course, but that's one way of traditionally thinking about this. So you have this essential bottom line requirement of lawful conduct, and you have fiduciary duties, but using those as the tools for going after violations of other areas of law is challenging. So as far as using fiduciary law for that, part of why that's challenging is because we have two fiduciary duties, care and loyalty. And under the duty of care, most states, including Delaware since the 80s, has had a provision that allows companies to exculpate directors, and now more recently officers, for personal liability, for their monetary damage for breach of the duty of care. Also, when you think about it, while we may want fiduciaries to use care, it's usually not that we're most concerned about when we're talking about the themes of this conference. It's really usually that issue around the legal obedience that ties to the themes of this conference, not the care that they use in their decision making so much. But whether they are trying to carry out their obligation of acting lawfully when they act on behalf of the corporation. So the duty of loyalty embeds a duty of good faith that requires that. It says that a director that sits on a board of directors, if they intend to violate positive law when they make a decision, is a breach of their fiduciary duty. And we see that this doctrine is developed, for example, in Delaware, to have two aspects. There's the intent to violate positive law aspect, and then there's the oversight aspect. Both are ways by which a fiduciary could violate their fiduciary obligation. If they make a decision and intend to violate positive law, that's one way. Another way that the law has construed their obligation is that they have an obligation to oversee the company's affairs in a way such that if they have an utter failure to put in place any kind of information and monitoring system to make sure that information gets up to the board about things like legal risk and compliance, that there is some fundamental bottom line requirement that if they have an utter failure to put it in place or to monitor it and respond to it, then there will be a fiduciary breach. In recent years, we've seen an uptick in use of that theory or claim, which is often known as a Caremark claim under Delaware law for oversight. And I studied this several years ago. I read every single case that involved a Caremark claim that went to the Delaware courts. And several years ago, there had been about 100. And there were only a handful that got past the motion, that survived a motion to dismiss, and none had gone to trial. Now we have several more handfuls, but none have gone to trial. But we've had some big settlements like Boeing, et cetera. So where does that leave us? Well, those are not easy tools, and also the shareholders that would bring them, these are mostly plaintiffs' lawyers firms. And with the current moment, I'll just wrap up since I see my time, the current moment is that we've seen real tension with where the doctrine was going in taking a more capacious approach to, for example, the Caremark doctrine. The judges that had been taking a more capacious approach have been under a spotlight, and we've seen that Delaware has really been dealing with the tension between calibrating the very things that are reflected by things like 102b7. We want to have a corporate law that isn't too unfriendly to the very people that are going to serve in corporations, such that they'll still want to serve, and they try to do their best. We don't want to create too much incentive for plaintiff lawyers to be constantly suing and creating more costs that the corporation itself will pay. On the other hand, if you don't have anything left, then you won't have any accountability. So calibrating that balance has been extremely difficult over time. And right now what we see is that Delaware has been making some amendments, not related to the Caremark doctrine, but mostly related to fiduciary duty of loyalty, interested transactions, and controlling stockholder transactions, in which it's clarifying in a way that it's tightening up a doctrine that had expanded over time that had allowed for more litigation of that type. So if anything, you would expect to see less of that going forward as Delaware has been trying to tighten up some of those very doctrines, and states like Nevada that have been competing have been going even further to clarify that there would be less tools for those sorts of accountability.
Okay, Miriam. Ellen, sorry.
My slides? So what I'm going to be talking about is corporate criminal accountability, but I'm also going to be discussing the constituents within that corporation. And basically, I'm going to focus on three things. Why? Because I'm a believer in the rule of threes. We remember things in terms of threes. So I'm going to look at the failure of the legal framework, the advocacy failures, and then look at the regulatory enforcement avenue. And looking at these three things, it becomes very evident to me that we're talking about three things that may be very separate, but when you put them all together, especially in our current environment, it really exacerbates the situation. So talking about the legal frameworks, I mean, there are a host of cases out there. I did back from 1987 McNally, which overturned the ability of the government to bring cases that dealt with the intangible right to honest services. Congress comes back with a statute. Even this statute has had many issues in skilling. They cut back the statute. They limited it to bribery and kickbacks. Every one of these cases, and this is not exhaustive, there are so many more cases I could have put up there, but each one of these cases shows the United States Supreme Court limiting, cutting back. One of the ones I want to mention is Arthur Andersen. So, in the corporate sphere, you don't go to trial. I could put on my hands the number of corporations that actually on a criminal case would go to trial. Because what basically happens is the government walks in and they say, remember Arthur Andersen. And that's all they have to say. Arthur Andersen won in the United States Supreme Court. Arthur Andersen is dead. And so even when you have a situation where the legal framework is cut back, it does have an effect. It does have an effect. And it has an effect in the corporate sphere. What I think these cases all represent are the statutory deficiencies that are existing in our system today. Congress is very poor at writing decent statutes. The statutes are not specific. The statutes are open with vagueness. I mean, you take even something like the recent Prococo case where the jury instructions are too vague and you get a concurring opinion by Thomas and Gorsuch who are saying, no one knows what honest services fraud encompasses. So we're going to see even more down the road, likely, of them cutting back and limiting what is out there on the statutory side of things. Looking at the advocacy failures, and this is the part that I think many people aren't noticing. And it sort of is a part that really contradicts itself in many ways, but it doesn't, if you look at it closely. On one hand, you have a lot of overreaching by the government. You take a case like the Yates case. They bring a prosecution under the Sarbanes-Oxley Act for 3 fish that got thrown overboard for being undersized. And that's an obstruction of justice. What kind of mad prosecutor brought that? That's what Skilling said. Excuse me, that's what Scalia said. But on the other hand, it was brought. And Scalia was not the one on the right side of the fence of throwing it out in that case. The second thing, in addition to overreaching by the government, the use of shortcut offenses, and this is one really dear to me, is you don't see the government prosecuting people for the crimes that they are committing. Martha Stewart was not prosecuted for insider trading. Martha Stewart was prosecuted for obstruction of justice, perjury. They're not giving that deterrent effect because they are not doing the prosecutions on what the actual fraud is. So yes, it's difficult to bring a white-collar case. They're intricate, and mail fraud's a bear. There's no doubt about it. But even with that, you've got all of these instances where they're filing cases under 1001 false statements. You say the word no to somebody, that can be a false statement, an exculpatory no. False declarations, perjury, obstruction of justice, easy to prove statutes in most cases. That's what the government does. You're missing that deterrent effect for the actual conduct. And finally, the last one that I wanted to bring out about the advocacy failures is how they're pitting the corporations against the constituents within the corporation. They have the corporation getting the benefit if they tell upon the constituents, if they bring forth the conduct of the constituents. Nobody's on the same page anymore. It used to be when the Upjohn case initially happened, everybody was working together. There was an internal investigation. Everybody was on the same side. Root out the problem. Let the corporation deal with the problem. That's not happening today. The minute you see the government coming in, what are the constituents doing? They're getting lawyered up because they know they're likely to be a target. And so there is not the symmetry there. There is no longer that ability to root out the problems within the corporation. These are the failures that I see in the advocacy sphere. And I mean, if you look at NPAs, non-prosecution agreement, deferred prosecution agreements, the corporation is going to pay the money. Yes, I do think that it costs them something, and yes, they're liable to put into effect some type of corporate compliance program, and maybe it will work. Hopefully it will. As we heard from Peter, I'm not sure how well it will work. But the new declinations of prosecution that we're seeing now that started in the last term, the declinations of prosecution, you give us everything and we will not prosecute you. And I should say, thank you for the introduction of saying I'm a prosecutor, but I've also been a defense counsel also. And as defense counsel, I'm looking at this and I'm saying right now, go to trial. Go to trial. Because I'm not sure the government is equipped to handle it, and that's frightening to me from the prosecution side and from the public side. The last thing is regulatory enforcement, and this all fits together in my opinion, and that is we have a decreased regulatory enforcement. We're seeing regulations being dropped, we're seeing agencies losing people right and left. What does that mean? It means it's going to be a delay process. It means that it's going to be a much slower process for people getting to trial. So you're going to have increased damage to victims. That increased damage is going to cause an increased fraud loss, which under the sentencing guidelines means that the individual person is going to wind up with a greater sentence. If they get caught, and to me this is like, the world isn't flat, the world is round. This is so obvious that you get a larger sentence if you have a much higher fraud. And by having that higher fraud, it's gone on for a longer period of time. Look at Bernie Madoff, how long it went on. Why didn't the SEC do it? Why didn't they catch him sooner? We all know why, but that increased damage caused damage to more victims, an increased fraud loss, and what did he end up with? This huge, ridiculous sentence. And that's something I think we have to look at, is putting these three pieces together and trying to see how are we attacking this advocacy failures, this regulatory enforcement, and this fact that the statutes just don't fit right now.
Fabio.
Yes.
Your turn.
Thank you. Thank you for inviting me. This is a sort of case study on what happened to criminal case and to me at the end. It was. It started with a great illusion that that period, time, 2008, 2010. You see the awakening giant of anti-corruption enforcement and the conference of corruption involving vast quantity of assets, and the idea of creating a global operational network of anti-corruption law, etc., etc. That time we formed our office, a specialized unit, and the idea was to change in some ways the approach to this kind of offenses, especially foreign bribery. So the prosecutor directs the police, has first-hand knowledge, and speaks with the police, but it's not dependent on their guidance by the police, interview directly the witness, the suspects, try to understand the story, the real story, not simply amassing shortcut offenses against one suspect. The prosecutor seeks also international cooperation, try to stimulate enforcement, local enforcement of the case. And that's the last point of our methodology, that was the risky point, actually. The prosecutor tries to go up to the chain of command of the corporation. This is to go into the heart of darkness. It's better not to go there. In this, these years of enforcement, we found some gaps and limits. I try to be very short, but especially in the field of the judiciary, whistleblowers and cooperating defendants can be intimidated, can be bribed, or both. The text up. The courts, that's a very sad lesson, that the court can be influenced, either subtly, messages from other colleagues, messages from my high-ranking judge, or bluntly, you are risking to put in danger the economy, the big company, 1,000 jobs, etc., etc. Then there is another problem, the allocation of the case. It can be diverted toward slow or shy or unspecialized panels. Hope this is meta. The media, I will be brief. Once an investigation starts, it's big news. For every media, left, right, whatever. You cannot afford to ignore the news. After some time, it becomes old, stale, stale. And so it would be the now for commentators to speak around, to go deeply, but commentators don't attract advertisement, and the big corporation can buy instead in their turn big advertisement. One word about victim states is messy. We tried a unique experience to work together with victim states, let's say Nigeria, Algeria, and other countries. It's a mess. It's really a mess because they open their cases, they want to take money, they want to get reputation, but when it turns to really cooperate and say, hey, we go after our big boss, you go after your corrupt politician, now you understand that the commitment is not that you can expect. And the power corporation of our corporation is there. They are friends. They are allies. They are political sponsors. So now let's go straight to the case. OPL 245 is, let's say, is in deep water in Nigeria. Is one of the biggest of Africa. It's just oil prospecting license. So is not discovering, is not digging and taking oil, but discovering. But there is gas, and there is oil. There was an agreement, and as a result of the agreement sponsored by the Nigerian government, two companies, Eni and Shell, paid 1.1 billion, and this money ended into the pockets of a former minister who had self-allocated this license about 20 years before. So there was an enormous conflict of interest. And unfortunately, this guy had been also convicted for money laundering later in France. So the Economist at the time made a fantastic article saying, safe sex in Nigeria. If you want to have a deal in Nigeria, take the government as a buffer. So the monies were intended to pay this guy and his political godfathers, the president, the oil minister, the attorney general, and in fantastic mails that I found, lots of sharks circling. A part of the price should be channeled back to the execs of the company. This is another feature that is very important. The corporation make this crime not only to get business abroad, but to get money in the pockets. So this is the scheme, but it's long to look, but please consider that the escrow account was with JP Morgan Chase London, so always a big bank. And the big bank transferred to Switzerland, and the transfer was firstly blocked because it was suspicious. And the bank persevered. And at the end of the day, you see that about 800 million went to Nigeria, and an enormous part, look at the last part down, left, right, an enormous part was taken into cash, simply cash, money. And this is not an assumption. This is something that we learned from the bank statement. So it's not our theory. You are interested to the reason why the court acquitted all the defendants. It would be long. OECD came and raised their brow, say, oh, this Italian court, they have double standard proof, very onerous standard proofs. They treat circumstantial evidence in a very funny way, in a piecemeal fashion. They could, and they don't understand what the relation between the various pieces of circumstantial evidence. And also large opaque payments to intermediary were considered not evidence of foreign bribery. So the last point is the most critical. In most cases of foreign bribery, the court acquitted all the defendants because there was not a detailed proof of the date, of the time, of the people who sat around the table discussing the agreement. I always said this is something that you can see only on Netflix, not on reality. So this is the aftermath. So prepare your for your tears. And so 17 March 2021, the Milan court acquits both companies and 13 individuals, including, for our risk and pain, the CEO, the current CEO, the former CEO, and the head of exploration. So big fishes. Never try big fishes. If you are not big enough, of course. 22nd of March, 5 days ago, after, in a separate trial, an assistant prosecutor general in appeal acquitted two middlemen in the same case that had been convicted before. because they had chosen a different path, a different procedure. And the great day is the 7th of June 2021. For me, it was a normal day. I went to my office and I found 3 policemen sitting. Oh, what are you doing here? I would like to look into your computer. Oh, interesting. And I understood that both me and my colleague were under investigation for concealing exculpatory evidence. This seems ridiculous because all the defendants had been acquitted 2 months before, but anyway, that was the charge. We will hope sooner or later we will be acquitted, soon or later. In June, same year, the 2 famous middlemen I said were acquitted. In July, the press revealed that also the chief prosecutor of Milan had been under investigation. And so, you say to go quick, and I'll go quick, but we are about the end. I tried to lodge the appeal against the acquittal, but I was, how you say, a lame duck, investigated, and I crashed the lot with the office of appeal. At the end, I lodged the appeal, and the appeal was withdrawn. End of the case. Last, the case was closed, but our case was not closed. And unfortunately, months ago, both me and my colleague were convicted. That is a strange way of being for a prosecutor. A prosecutor prosecuted is strange. A prosecutor convicted is more strange. And I'm serious, I'm not joking. I'm trying not to be pathetic, but is what you see. So practically, the lesson, if I have just 1 minute to finish, okay? The lesson is the deeper you go, the more risky the investigation becomes, first. Second lesson, you are surrounded not by sharks, but by people who are not interested because they think it's a normal business practice. And this is pervasive. So you feel alone. So you feel almost crazy. You speak with the Nigerians, and for them it's important to take money, not to build up a case. That's the state of things. We hope it will change. Thank you.
Okay, Jennifer.
Wow. He said that you only see this on Netflix, and I'm beginning to wonder whether you should be connecting with Tom Wright and getting the rights of your story sold. So corporate misconduct in the law. So why do so many of us focus on this? And maybe in part it's for the drama. Maybe in part it's to confirm some of our suspicions about the stage of capitalism in which we are now engulfed. But quite honestly, I hope that the reason why we're focusing on this is because we're hoping to prevent corporate misconduct and not just respond to it after the fact. And we began with Elizabeth focusing on the civil law system, mostly at the state level, and how that turns out to be fairly inadequate. It's not even, corporation law isn't even designed to deal with some of these extrinsic, these activities or behaviors that go beyond decision-making among the directors, the management, and the shareholders. And when you try to use that regime, or even the federal securities laws regime, to deal with, to essentially respond to corporate misconduct, it doesn't work very well, not just because of the substance of the law that she's talked about, but also some of the procedural hurdles you have to go through. Then we listened to Ellen talk about, both Ellen and Fabio, although the Italian perspective, talk about using criminal accountability, again, after the fact, to respond to some of these major cases of corporate misconduct. And we have, on the one hand, as Ellen described, we have Bernard Madoff, for whom, who should have been exposed a lot earlier had the SEC understood what Harvey Markopoulos had been saying. And on the other hand, we have a small fisherman being caught up in this insane obstruction record-keeping statute because he threw some fish overboard. And so, and that brings me really to this question I think we've been grappling with at the whole conference, which is, if we want, assuming for a second that we can all agree upon certain principles of certain activities that we think should be prevented, whether they're criminal or just merely corrupt, right? And we can talk about outright bribery. Maybe some people think paying for access is fine, but we could come through, and say a series of things that shouldn't happen. Lying to shareholders in order to get them to make buy or sell decisions, bribery, kickbacks, whatever that list is. Even if we could agree upon that list, the question is, how do we use, what's the best way to use or reform our existing legal system in order to effectuate that? So to get to that, I'm kind of looking at this, even though I'm a lawyer, or I guess a law professor, from a little bit more of a sort of a sociological perspective. So you know how we talk about in money laundering, know your customer? Well, here in terms of law, I want to talk about know your audience. And so when I say know your audience, if we're trying to create a legal regime that can do all of these things, prevent, some prevention, some intervention, like prevent bad actions before they start, intervene before these things grow out of control, and then, of course, my phone thinks I'm talking to it. And of course, after that, do something to respond, right? Whether that is punishing or some sort of new regulatory regime. So if we're thinking about those are the different things that law can do, again, prevention, intervention, and response, who is the audience we're trying to deal with, right? Because law also is sending a message. So I decided that we kind of need to triage, and I just broke it into threes because I always think about corporate misconduct in these categories. I think we can start with, first, the criminal organization that is essentially criminal to the core, like almost from day one. So imagine that if you believe what Diane Enriquez wrote in Wizard of Lies, essentially that Madoff was probably a fraud from the beginning, right? So we've got the Madoffs. I would even put Enron almost in that category. Maybe Bethany might disagree that maybe initially they thought they were doing the right thing, but at some point Enron became essentially, practically a RICO enterprise, right? So we get these criminal to the core at some point organizations, okay? Then there's this other category, I would call them opportunistic offenders, right? These are just your average business organization that's gonna engage in some kind of cost-benefit analysis or respond to what's happening among their industry peers. So I would put the corporations that were engaging in a lot of earnings management, cookie jar reserves in the 1990s, early 2000s in that category. I would even put the giant banks during the run-up to the global financial crisis in that category. I would even put Wells Fargo in that category. These are organizations that are not corrupt or criminal to the core. They provide really important either goods or services, but they're taking advantage of what they either perceive as a lax regulatory environment or the fact that the numbers just look so good. Like how could you resist if you've looked at the numbers of putting on these interest-only subprime mortgages? The numbers are too good, everyone was doing it, I guess you keep dancing until the music stops type organizations. And then the third type is I would call the sort of one-off offenders. These are the folks who get in a scrape. I'm thinking of them, they get in a scrape, maybe there's a bad apple in the organization, maybe they're desperate to make their numbers, they maybe face an overzealous prosecutor, our fishermen are in that situation, or my best example would be Abacus Bank, that small bank in New York City that ends up being like one of the only banks prosecuted, the only one certainly by Cy Vance Jr., and was the subject of the documentary Small Enough to Jail. So if we imagine that there's these three bundles, right? Criminal to the core, the opportunistic offender, and the one-off offender. I think our system perversely favors these criminal to the core models in terms of we don't prevent those because they are so audacious. It's hard for, let me say it differently. I think that prosecutors need to actually take a good look and try to decide if something is that kind of organization. Because folks that have models that are criminal to the core are going to be very savvy about not getting their fingerprints on anything, not creating any kind of documentation, and they'll probably grow unchecked, and they're so audacious it's hard to believe that's who they are. So they tend to ingratiate themselves with the right organizations and regulators. Think about Madoff's niece or the affinity fraud he was involved in. And I think they create tremendous harm until they implode. But they're really easy to prosecute. Like look at Madoff, right? At the end, he knew the day was going to come. The Warren Buffett type day when the tide is out, we can see who's not wearing shorts. Well, he knew that day would come, and he figured out what he was going to do. So the fact that you can prosecute Madoff later, I mean, maybe it's good that they were able to claw back the money and make a lot of people whole on paper, but the prosecution of Madoff doesn't prevent the harm that he caused. And so we need to do a better job in identifying those, and I think prosecute those folks early, I think. The other the perversity of our system is that last group that harms so few people. Someone who gets, so the sort of one-off offender, I think they're really easy, low-hanging fruit. These are folks who do the right thing. They're not covering their tracks. They're not planning for getting caught one day. They're just sort of desperately acting. And I think it's unfortunate that they often get targeted, and I think we should go lighter on them. Now, the problem, of course, in the world we're in is almost every other business falls into this sort of middle opportunistic offender, right? And so what do we do? And I describe these opportunistic offenders, it's almost always like there is this sort of industry practice. It's not one of them, right? And it's sort of what Judge Rakoff was talking about. We've seen this coming for a long time in the crypto space, right? It's this group that's kind of acting on the edge or beyond the edge of the law, but they're all kind of running with the pack and no one kind of stops them. So what does that mean, I think, for how we deal with this given the existing legal tools we have? And I think we would do better if you could start with, for example, assuming an SEC that would care about this, you could start with the SEC or you could start with Congress having hearings not after everybody's lost their money, but ahead of time. And the reason, and sort of sunlight on this, and what I'm thinking about this is not explicitly, but sort of implicitly under British law, this idea of comply or explain. So it's sort of a soft law regime in corporate governance where you have to follow certain practices or explain why you don't. I would like there to be norms enforced, whether it's through Congress or the SEC, about certain behaviors. And if you think a whole industry there's a problem, like whether it's, think of the big tobacco hearings, bring people into a space and then start enforcing one by one I've got 5 minutes, thanks, to try to prevent this. But I think the problem is it's not a one-size-all problem. I mean, I think we hear people saying, well, there's so many different regulations, it's hard to follow them, and that is true. But are we dealing with a business, even if they're going through, and I would even group the companies that have several NPAs or DPAs on their, is it, when you sit down with them, are you trying to, as a prosecutor, as the DOJ or the SEC or the Fed, meaning the banking regulator, are you sitting down with them hoping to get a settlement and make them go away? Are you trying to change behavior? And there's so many ways you could do that. I mean, one thing I would do is get rid of the boards of directors if you have these problems when you enter into these settlements. There needs to be, you don't change culture at those opportunistic offending companies simply by waiting till the whole thing implodes. And then it was good when we prosecuted people after the earnings management scandals and after Enron. Wasn't good when we didn't do it after the financial crisis. But I guess where I'm landing with this is we have these systems in place, and even when you have the most successful and zealous prosecutor, and I know this is Italy, not the US, but you have Fabio here, who had all the tools in the world. They even have a tool to appeal. It sounds like this, for American lawyers, I think it was shocking to hear you can appeal a criminal conviction. In the US, the prosecution doesn't get to appeal. That would be double jeopardy. He's got all the tools in place. And, I would have loved to have him instead of Merrick Garland around here. But even so, look at what he is up against, right? Look at what he is up against going, and how many of those cases can you bring against corporations? So I think we really do need to think about the prevention side of this regime and not do what we normally do, which is see the sort of corporate crime waves and then crackdowns, then crime waves and crackdowns, and nothing really changes. It's a cost of doing business. We need to change the way people do business, not just tax them on the other side and say we did a good job. I'm going to actually finish there and reserve my time for later.
Okay, awesome. So I want to follow up in a few ways. First, I want to bring up examples not from finance, that are pretty egregious on the issues that came up here, specifically, regulation plus punishment together, and two obvious cases in the U.S. and there are some in other countries too: Purdue Pharma and Boeing. So both of these cases have a sort of a, Purdue is probably the most spectacular, a lengthy period of time in which it was very clear that Purdue's marketing was misleading, and that included the way they got the FDA to approve OxyContin and the language around addiction, the addictivity or whatever you call it of OxyContin. This is starting in the mid-90s. And going to the key year of 2007, when everything about Purdue about OxyContin was known, and the harm was in front of us, and there were victims warning the executives, and the Department of Justice failed spectacularly at that point by going after executives for responsible officers, strict liability, misdemeanor with the best lawyers in the country, defending them. Some were already and have become famous since, Mark Pomerantz, Mary Jo White, people like that, and nothing actually happening to these very executives, not to mention the Sackler family, et cetera, some of whom were very, very involved. And this continues for 12 more years. Now, the original sin was the FDA being fooled. So that's in the regulation space. And very similarly, in Boeing. When Boeing had their cases and that spectacularly awful deferred prosecution that was then undone because they kept having safety problems, what was headlined as $2.5 billion was called by Jack Coffey one of the worst DPAs ever, because most of it was actually just product liability to the victims and to the airlines. At that point, what was the crime? The crime was defrauding the FAA. Why was the FAA being defrauded? Why did the FAA allow them to tell them whether they needed to train the pilot or not? So, it goes back to being, allowing yourself to be robbed, in the case of Cum-Ex, allowing yourself to be fooled and deceived, delegating regulatory, authority to the regulated, and all these obvious things about, regulatory capture. And then, by that time, it's late, as our panelists have pointed out, and DISCUSSANT, after the fact. There's nothing to do for the Purdue victims now, all of us being included because of all the public money that went to that and the enormous human pain that you can't even possibly compensate for. So the extent of failure of the government on a Purdue or a Boeing, and again, the second Boeing crash was because it was still allowed to fly, blaming Indonesian pilots for the first. Anyway, so we come after the fact and say, oh, bad corporation, do this and that, while allowing them beforehand. So I think that is in line, so my view is in line with that. What I wanted to ask you about goes back to the previous panel, compliance programs. So I have a very cynical view of compliance programs. Number one, compliance, and so I want your response to that. Compliance programs are meant to do two things. Supposing they check the boxes, I'm not even sure there are thousands of laws that they have to comply with. So what does a good compliance program even look like? For this law, for this law, for this law, for this law. If you pass the bar, you get out of these Caremark personally, as a director, as an officer, etc. So you buy that. And if, should there be a lawsuit, insurance pays. Boeing, insurance paid. So nothing happened to any person. And then number two, discounts from the Department of Justice. So if you have a compliance program, you know, they won't charge you. I mean, Peter was just saying this, they'll give you 0 fine. If I was asked to come forward about my speeding ticket and get 0 fine, speeding is good. I speed and come forward and pay 0 and done. If I was caught, you know, I'd be, you know, $1,000 in my license, you know. So in other words, you give enough of a discount, sure, you know, it doesn't deter anything. So I don't see compliance as my point is that the Department of Justice is both wanting people under the bus, which is to your point about conflicts with the employee. Boeing, again, they threw a test pilot under the bus, immediately found acquitted, okay, immediately. But they got some discount for that. And all the stuff that they say is incentivizing corporations to do stuff, as long as they're not, the corporations comply and investigate and do all these things voluntarily, how is that really deterring?
So can I just respond? Yeah. So it's funny that if you only encounter compliance programs in the context of, you know, the prosecution guidelines of the DOJ, then you don't fully appreciate actually how super important compliance programs are. And I speak to when I was working in-house at Fidelity, right? Some compliance programs can be automated. For example, money market funds have to have a daily weighted average maturity of 60 days. Well, that can be automated, and you need compliance to come in and set that up. And there's other things that, compliance is actually what the general counsels want inside the company. I think the compliance that gets a bad name is we're bringing in an outside monitor, ex post compliance, or the compliance that, if you have a strong compliance program after Enron, then maybe we'll deal better with you. So I just want to say that there's a good side to compliance.
From a corporate law perspective, some of the cases, Caremark cases, like the Boeing case itself, Vice Chancellor Morgan Zern's opinion starts by explaining how awkward it is to even be talking about this through the corporate law language, because the lingo is that there's been a corporate trauma. That's actually what the shareholders are suing about. And that is to say, people died, terrible things happened, but that's not what the framework of that particular shareholder litigation is about. Instead, that litigation is about the fact that because there was an alleged failure of oversight from the board, that the shareholders suffered a harm because the corporation had the trauma of paying out the billions and the settlements and the government fines, et cetera. And that is part of what's so awkward about using Caremark or oversight liability for any of this. And in Boeing, one thing that's very interesting, though, is that there was both a prong one, what's called a prong one, and a prong two claim that survived the motion to dismiss. The first prong is that there has to be enough of a showing that there was and either one is sufficient for making out this claim. You don't have to have both. It's not an element test. It's either one.
Faith.
There's an utter failure to put in place any kind of system. But one thing that's notable about that opinion was that the Delaware courts moved, at least for some time, towards more focus on it being at the board level. And in the past, there had been quite an easiness to saying this is the hardest theory in corporate law to show, and any kind of compliance system will suffice to fill the prong one obligation. But you had cases like Boeing that looked more carefully, and this was after the Bluebell Creamery case of Marchand v. Barnhill, in which people died because of listeria from the ice cream of Bluebell, in which the Delaware Supreme Court, in Leo Strine's opinion, had said, no, you have to look at the board level. Were they doing anything at the board level to get the information up and caring about the food safety regulation or whatever else? So that's interesting. But in Boeing, you had both the prong 1 and the prong 2, in part because there were the 2 airplane crashes. Looking at what did the board have in place in the first place, if anything, and how did it respond then when there were red flags? So Boeing is quite an interesting case in that way, and I think that was part of potentially why it's one of the largest settlements for a Kerman action. But I would just underscore again how awkward the whole thing is doing it through corporate law later, to Jennifer's point. And other cases like Duke Energy that came before, in which D&O insurance paid for it. So you have exculpation on duty of care, no exculpation on loyalty, which encourages the plaintiff's lawyers to frame the cases as Caremark cases instead to get to a settlement, and you don't end up getting to trial. But you have cases like Duke Energy that show what happens in other situations and how hard it is to even make out those cases, because in Duke Energy you had a company that had allegedly hundreds of environmental regulations being violated daily, but they had captured the regulators, to your point, Anat. And there was a revolving door, and that they didn't even survive the motion to dismiss. Yeah.
So in the criminal sphere, it's even more interesting because you take a case like BP, where they had an initial oil spill, and they went into court, the victims went in, hired a private counsel to try to disrupt the deferred prosecution agreement. And the court has very little leeway on these instances, and that's problematic. What happens, you then had the major BP spill, and what it resulted in? It resulted in a plea agreement as opposed to a deferred prosecution agreement or a non-prosecution agreement. And that plea agreement, what does it entail? It entails the fine, it entails the monitor, it gets basically a lot of the same things that you're looking at before. So I think that's a perfect example of, are you going to put people in jail, which did not necessarily happen here, or are you going to start looking at how do you involve that corporation to make the changes within itself?
Okay, final question on the popular question, thing people are asking that got. Oh, please, sorry.
Compliance.
Yes,
Compliance.
please, compliance.
Just some adjectives.
Yeah.
In Italy, compliance is not totally exculpatory, so this is important. In the United States, I think it creates a sort of parallel business, parallel legal business. That's my impression. The adjectives. The compliance can be obvious, useless, designed to blackmail internally, or designed to hide or to claim good faith.
Okay, so the question of executives going to jail. Okay, it's, we don't want people, impoverished. And when I took a white-collar crime course, David Mills said, was teaching with Bob Weisberg, who I was hoping would be here, but is not, said, well, just impoverish them, send them to personal bankruptcy, except I kept asking over and over again, everybody I meet in the space, have you ever seen an officer, a director, anybody who actually was personally financially, not in jail, in serious trouble? And the answer was no. So that doesn't even happen. But here's my question. For criminal, at least, which is, you can't insure against felony, should we lower the bar for responsible officers? With proofs, not strict liability. In other words, you had to repeatedly, it's a long discussion we had, is willful blindness, if you're a responsible officer, that means you are in a position to prevent something. If you repeatedly fail to prevent it, shouldn't that be criminalized? If you prevented your corporations from committing a crime repeatedly. What do you think, Jennifer?
So I want to sort of back up because people maybe aren't as familiar with the responsible corporate officer doctrine.
Yeah.
And both the doctrine and sort of embedded in some of the statutes. So
it's only for some laws, though.
Right, exactly. So for some laws, mostly public safety laws like food and drug laws, certain environmental laws. There is a misdemeanor if you are defined as a responsible corporate officer, essentially meaning that you were in a position of power and authority to prevent this problem from happening and you didn't take action. In theory, the doctrine is so broad to suggest that you didn't have knowledge. I have never seen a case where they brought it against someone who didn't have knowledge. Recently, the doctrine was not overturned. It was reinforced with the DeCoster case involving Quality Egg, this father and son giant egg conglomerate, where they pleaded guilty to the responsible corporate officer offense about knowing about and kind of covering up all this salmonella, millions of eggs, not in millions of eggs, but they have millions of eggs that they produce through their factory farms. And they pleaded guilty, and then they appealed their sentence, because each of them were given fines and 6 months. They appealed the sentence saying this was unconstitutional, and the Eighth Circuit upheld their sentences. And the Supreme Court, I believe, did not grant cert, or they didn't take it up. I don't know which. But so that's in place. So to me, the question Anat is asking is, should we expand this responsible corporate officer doctrine, misdemeanor only up to 1 year imprisonment, to other areas of law? And I'm definitely for that.
And not necessarily with strict, felony, beyond a reasonable doubt, but you had, there's still to prove a lot.
They did, by the way, in the first Purdue Pharma criminal case, 2 of the executives did end up pleading guilty as responsible corporate officers, although the court did not give them jail time. But that was because pharmaceuticals, right? Right. So I do think it makes sense to expand it. I've written about that. Mary Jo White doesn't agree with me. She came to my law school to give a talk about something and specifically mentioned that she didn't. I wasn't there that day. First she said nice things about me, and then she said that. And of course I can understand, given the client she has, why she would have that position.
Okay, I think it's time to open it up for questions. We have 15 minutes, so let's go for it.
Why is it that these people were able to escape in Italy, and for similar things were not able to escape in France with commissions? And how much does the politics have to do with this? Because one aspect you're not evoking is that some of the commissions don't only go back to the Italians; they go back to the party in power to finance campaigns. And this is a general rule, regretfully. And we can see it with Berlusconi, and we could see it even with the RPR in France and so forth. So could you talk a little about that? And why is Italy a bit different from its other European peers?
Italy is a little bit different because we have a regime of mandatory prosecution, and we are independent. We are not under instruction of the Ministry of Justice or so. So we can ride wild and do whatever we want, of course, under the law. Regarding the interplay of politics and grand corruption, I think it's an extraordinarily interesting matter. And it can be seen from very different angles and point of view. So sometimes the fact that there is a strong political campaign against someone, against also the head of government like Berlusconi, can help prosecution, because if he is unwilling to have supporters, but we had. In other cases, there could be a sort of subterranean embargo regarding your investigation that comes from politics, but you don't see. For example, in the case of the big state-owned companies. And if you shift from Italy, that is let's say a normal European country, to other countries, you see that there are effects, but are not always the same effects. In Africa, for example, the things are different, but in any case, the politics is underlying every kind of grand corruption inquiry.
I have a question which is pretty simply stated. What do you want me to do as a business leader? I hear we've got to find the bad actors and deliver them to justice. That will be rewarded. That's a good thing. On the other hand, then we're not on the same page and we're throwing them under the bus. Which do you want us to do?
Well, the throwing under the bus is, if you're asking me, is about lower-level employees. I mean, the problem in the multi-layer corporation is, where the intent and the benefit from the crime is, or from the misconduct, where's the action of it. And, the action is without intent oftentimes, so there's no way that the low-level employees of Wells Fargo got up in the morning and decided to defraud customers. I mean, they clearly were not intending for themselves, except to keep their jobs because of incentives from the top. So the fact that the people at the top were failing, I mean, in the report by Sherman and Sterling to Wells Fargo, which really was the first thing that got me interested in this question, they said that the board, this is a report commissioned by the board, by the independent directors, paid for by the shareholders, presumably. That report said, self-investigation of what happened, that the board and the executives, John Stumpf, CEO, had a disinclination to see the problem as systemic. They didn't feel like seeing the problem as systemic, even though for a few years it was known that their aggressive sales culture was causing employees to oversell, 80s great accounts, or to open accounts fraudulently. And so, where is their responsibility? In the end, after all this scandal, because it was such a simple fraud, it did get to Sharon, to the executive in charge of that community bank, and there was a sort of settlement there. Stumpf left the board, he's not on the streets. And last I checked. So that's the issue. Throwing under the bus is what they do to get a lower sentence, because the Department of Justice says, give me somebody, give me evidence, and then they would violate. Then the employee would get abused because the employee might be talking to the lawyers of the company, not realizing that they're not on his side or her side. I mean, you tell me about that because I read about it in some law review papers.
Yeah, it's a real serious issue, and it's happened in a few cases now where they're doing the internal investigation, they're talking to the employees, and they're supposed to give an upjohn warning. I would say the vast majority do give an upjohn warning today.
What's an upjohn?
Upjohn warning
get a lawyer.
is, it's almost like a Miranda warning.
Right.
In other words, I'm not representing you, I'm representing the company. Anything you say to me can be used against you, and we hold the privilege as the company, not you. And you have to keep that privilege. I may have missed a couple of steps along the way, but that's the essence of it. And basically what some of the employees then say to the individual is, well, do I need a lawyer?
Yeah. Right.
And that's the awkward situation for both parties. I mean, what I think is the right thing that should be done here is the lawyer should be saying to them, maybe you do need a lawyer, and maybe we should get you a lawyer, and maybe we should pay for your lawyer, okay?
Right.
But that doesn't always happen.
We call that the Witness Protection Program.
Rick, you want to say something?
If I could, I'd just like to make a comment on the Italian case.
I wanted you to do that.
And that's because some of you know, I think, that I've known Fabio even before the Eni case. And like many in civil society who worry about foreign bribery because the impact on poor countries, we put a lot of hope in a successful prosecution of this case. The evidence that Eni and Shell had paid this bribe was just overwhelming. And of course, the largest bribe we have on record, $1.1 billion. There may be other bribes, but in any event. So then remember that Italy, like 45 other countries, now have an FCPA-like statute And not only do they have an FCPA statute, they get together every 6 months in Paris to review how each one is doing in terms of enforcing their statute. And there's a review of Italy's compliance. They're interesting what the next review of the US compliance will be. But when things started to go south in Italy after the acquittal, we did everything. Global Witness, HEDA, represented over there by Lanre, and others, let's get the OECD to say, Italy, you're not in compliance. And we had some success at first, and then politics, diplomatic, and if we can't get Italy to enforce its anti-bribery law, and we can't get the other countries that are part of this international convention where they all promise each other they'll enforce the anti-bribery law, what the hell do we do? And if Italy gets away with it, who's going to stop? Now we know the US has paused. Who else is going to stop enforcing their anti-bribery law? And what does this mean for the poor countries of the world? And I'm open to solutions, as is Fabio.
Miriam.
Okay, so at the risk of starting a fish fight, I want to push back a little and then also for those who bring up example of overreaching, the Yates case. So for those who don't know the Yates case, a fisherman is out at sea and someone from the state's fisheries department who's sort of deputized to do this boards his ship to measure the size of the fish he's catching. And that's okay, that part is all kosher. And it turns out that he's catching grouper that are like 3 inches or whatever, 2 inches too short. And as I always tell my students, imagine if you were the fisherman who's in competition with this guy who scrupulously follows the rules. Your catch is probably smaller because you're throwing back the fish you're not supposed to take. Anyway, this guy's got 2 short fish, and the fisheries guy says to him, okay, collect all your fish, put it in the hold, and when you dock, we'll weigh it, and you're going to be fined. Okay, so now he docks several hours later, and magically, the fish have grown. The short fish somehow disappeared. And eventually it comes out it's because he told his crew, a member of the crew, get rid of the bad fish, we'll fish for the good fish, and this way I'll escape the fine. Now, I understand that if someone really were sitting and saying to themselves, should I prosecute Boeing or Fish Guy? Yes, it would be absurd that I would choose Fish Guy over Boeing. But of course, that's not what actually happens in the federal government. That's not how things are set up. And in fact, the people who brought the fish case would be bringing some other case for some other, regulatory violation. And so, I have a hard time, I gotta say, I ended up agreeing with Justice Kagan, who writes the dissent, who says, I don't know, when I read a statute that says you shouldn't conceal or hide any tangible object, fish is as good as anything else. And indeed, there was a misdemeanor charge as well that the court did absolutely nothing with. It just stayed right there. So the court didn't say, how dare you prosecute this nice man. What they said was, we don't think this statute, because of the history of why it was enacted, and we don't think it really applies to fish, which, by the way, also meant, as Justice Kagan pointed out, if instead he had had a logbook and the logbook indicated how short the fish were, and he tore that logbook up, there's no question that that would have actually qualified under the very statute that Justice Ginsburg was interpreting that many of you guys think, oh, that's overreaching. So it's hard for me to see this as overreaching, except the fact that he's a lower middle class guy who's selling fish. And then it's really not about the statute at all or overreaching on the statute, because if Mark Zuckerberg were out in his yacht for the weekend and felt like playing fisherman, and he had the same facts, he got some fish, and then he threw out the fish, and then he docked, and oh my God, it turned out, he faked it, you all would be saying, oh my God, expressively, of course we have to bring a case. We have to show deterrence and put our foot down. And okay, you say you wouldn't, but I can't help but think that some of the very folks who have an issue with Yates.
Can I get in a little fish fight? How many years did they wait?
Next.
How many years did they wait to prosecute?
Yeah, I
that
think
case?
it was towards the end of the statute.
Several years.
Yeah.
And they only prosecute. And by the way, fish move around; they flop, right? How do you know if it's like
Yeah,
15
but he was found
inches or
guilty.
13? I mean, come on.
No, but
It was-
Jennifer, he was found guilty, and more importantly, his crewmen admitted that he did it.
But it
So-
was not found guilty of the undersized fish. He was found guilty that there was 69 brought back to shore instead of 72.
But I think that's
so it was
meaningfully
3 fish that got
All right,
thrown
but it's
over.
meaningfully wrong to lie about this stuff, and I think that's
I
the
could
thing,
argue
you know.
your side on a different day. Yes, I understand.
I think it's meaningfully wrong to lie about things. And so I think in the zeal to point out ways in which the government is overreaching, I can think of lots and lots of cases of overreaching. But sometimes in our zeal to point some of these things out, I don't know that we really, I don't think we always pick the best examples. That's all. And I actually, that one always gets me sort of excited. So there you go.
Rohit, you want to?
Yeah, I wonder if you could, obviously, all of the incentives are usually against a meaningful resolution for severe corporate misconduct. And the list, I think, goes well beyond what is in the literature, frankly. But do you feel that there's any procedural changes that could be small but meaningful in changing some of the cheap settlement, weak settlement pressure points? You know, I have always thought about, should there be more public comment or judicial review of settlements? Should there be a ban on non-prosecution agreements or deferred prosecution agreements? But more broadly, I think I've thought about, should we really reduce the legal penalties, not the restitution part, but the financial penalties in exchange for moving to more structural interventions? You raised the Wells Fargo one. The only deterrent effect of the Wells Fargo case was the Fed's asset cap. It was really not any of it was not the CFPB fine, I think. It was not any, it was the asset cap. So should we be de-emphasizing or disincentivizing some of these financial penalties, which we know overall are, as the judge mentioned earlier, are below the ill-gotten gains often?
Does anybody want to answer?
One really quick thing. I mean, I'm sure you've probably seen the television series Succession.
Yeah.
And, it's a number, and that's the problem, right? And so I do think, there should be shorter, the statutes should have, and the guidelines should call for shorter sentences, and the person responsible, and maybe it is someone they throw under the bus. I don't know, but I think you need to actually I would rather have a trial than just a settlement, because I think a trial, people they don't like to lose control when they're that powerful, and they don't like to be embarrassed publicly. Just going through a trial is a trial. That's what should happen. And the fines, they get paid by the shareholders. It's just a cost of doing business. I would like to see trials.
But what's the procedural piece of to create the disincentive to the settlement toward the trial? I mean, that's what I'm trying to, there are some agencies that actually sometimes do reject the settlements that are recommended to them. There are rare judges that do it. But what would change that?
Well, I mean, Ellen talked about this. Do you want to respond to this?
Sure. I think it's really complicated. I mean, because of the fact that they have to figure the cost of doing business. And the cost of doing business is not going to trial. Simple as that. I mean, if you go to trial, it's going to be a much larger cost. There have been a few. W.R. Grace won. They went to trial. They were successful. But the cases, and you could say Arthur Andersen is successful, but the company went bankrupt. So the success and factoring that in with the actual cost makes it near impossible. I think it needs restructured completely. And that's kind of what I was getting into, that you need to have the corporation and the individuals within the corporation on the same side, trying to root out the problem and giving them an incentive for doing it, not giving them the incentive for ratting on the person. And I hate to use that word, but that's the word that a criminal defense attorney would think about. I mean, you need to give the incentive for them to get some publicity, get some reward for having done the right thing. You look at all the companies that have gotten deferred prosecution agreements, non-prosecution agreements. Most people don't know who those companies are. Yeah, there is a place you can go to look it up, and there isn't that transparency as it should be. That would be helpful if there was a lot more. The government has recently gone to putting some of them up, but it's really not effective in bringing it out because it's a cost of doing business right now.
Okay.
1 minute more?
1 minute.
Just 1 minute.
Sentence.
I don't think that change in the law, we have similar regime, and basically is a matter of wanting to risk or not, to go deeply or not. Simply that. So if the prosecution has the indication not to go too deeper, they stop and settle, and that's all. Otherwise, they can risk. We can risk. It's basically like that. It's just a matter of balancing the profit and loss.
No, I understand that. I think, though, that if there's a near consensus that there is not enough that gets litigated to judgment, and if that there is not enough in terms of the incentives of the actual enforcer, I mean, this is the thing that I think actually needs to change, because there's a lot of scholarship on how it's broken, but oftentimes when you have an enforcer regulator who wants to do it, the structural forces and procedural forces are not there.
Definitely.
I'm afraid of the opposite happening at this point, and that is people are going to go to trial and they're going to be successful.
I want to thank Domenico. I want to thank the crew for all the audiovisual. I want to thank the virtual audience that we had. There were actually a lot of people watching this. Thank you all for